All right. Hello again. This is Ben Hitchcock Cross talking to you today. We are reading from Celero versus Dell Chemical Corporation. We're now in the law section here. Briefly put the fight between the owner of the Dell Chemical Corporation and Mr. Celero. Mr. Celero continues to work for them to train the replacement. He does some things, including copying records on behalf of somebody else, and I don't know what else. And the co-workers go to the owner and say that he's being disloyal. Owner doesn't check anything, any evidence to the contrary, and says that there was no conversations with the guy out in Reno who asked for these records, according to the plaintiff, and doesn't really seem like he did much at all to investigate whether or not what he was saying about him, the plaintiff, were true, and continues to make these statements about him being disloyal for 5 years thereafter, causing serious damage to the ability of this guy to get a job. All right. So here we are reading. There are defendants in their brief raised three principal issues. Did the trial court err in its instructions to the jury? Was there sufficient evidence to suppose the jury's verdict support, and were their damages awarded excessive? The first issue the defendants allege is that the trial court erroneously instructed the jury in three respects. One, as to the what is quantum of proof necessary to overcome the conditional privilege extended to the defendants on this occasion. So they have a privilege. I guess they're clear on that. The employment privilege, so called. And it's the question of what's the standard for that privilege? What's necessary to overcome it? The quantum of proof necessary. As to the proper test applicable to determine if punitive damages are allowable, and C, as to the proof necessary to satisfy the test for the allowance of punitive damages. So I'm going to try to talk about punitive damages separately, and we're just going to focus basically on this key question: is what does a plaintiff have to show to overcome the employment privilege and defamation? That's what we're talking about. Hint, it's malice. All right. The plaintiff very properly challenges the right of the defendants on this appeal to challenge the trial court's instruction as to the quantum of proof to require to find express malice in this case, for the reason that the issue was not properly raised after verdict, and therefore the trial court was never afforded an opportunity to respond. Whoa. Defendants submitted 4 proposed instructions at the close of evidence, 2 of which read as follows. Before you find that Mr. Bagmill defamed Mr. Celero, you must find, by clear and convincing proof, that the statements uttered by Mr. Bagmill were published with the knowledge that they were false, or with reckless disregard of whether they were false or not. Citing Polson versus Hembrecht. There's good and bad in all things, and one great thing about Wisconsin law is the names. And we take great joy where we can in this life of ours. Before you are allowed to find punitive damages, you must find by clear and convincing proof. Okay, express malice. Express malice is ill will, envy, spite, or revenge on the part of Mr. Bagmill towards Mr. Celero. Both of these instructions would require the clear and convincing quantum of proof. And the first instruction, which really goes to the issue of whether a conditional privilege is abused. The instructions erroneously includes the constitutionally protected actual malice test as to what constitutes malice, which is not the standard for express malice discussed elsewhere in this opinion. While they do not seem to any longer explicitly argue that the trial court refusal to so instruct was error, the defendants do argue that the evidence does not meet that test and that a new trial is required on that grounds. Got it. I'll translate that for you. So they're saying that this is the 2 proposed instructions by the defense. And they're saying you've got to find out that there was knowledge, was reckless disregard of whether it's true or not, and then you also need to find before express malice, and then they defined express malice: ill will, envy, spite, or revenge. And then they're saying that the defendants agree that this is not the right statement for the conditional privilege, right, with actual malice. But then they say that that the they're still win. That's the bottom line. Okay. I think I saved us like three tedious explanations. No objection was made to the lack of actual malice in the instruction. The alleged errors would therefore be preserved for appeal if they had been properly raised again as grounds in the defendant's motion after a verdict for new trial. However, in that motion, the defendants asserted only the most general grounds. Okay. Yada, yada, yada. You got to raise the issue first at the trial court, or you lose it forever. Do, 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 do. Great. However, were we to consider the objections raised by the defendant, we would rule against them. I don't like these. I don't like these arguments. I don't. Or decisions. And I'll explain to you why. So we just went through a page and a half of why the defendants technically can't raise this argument. Okay? And that they're finding on the grounds that they can't raise the argument. But then they're also, and I mean, then they're saying on um, that we're just going to discuss this, but we would rule against him, but we don't have to rule against him because he screwed up, ha ha ha. And I mean, this happens so often that there must be a very good judicial self-preservation reason for doing this that I don't understand. I guess it's for appellate reasons is really what the issue is. But I don't, to the extent that the courts are called upon to make these kind of decisions, I think they should. I think that's the work. I think that getting paid the big bucks, ha ha ha, to be a judge means that you should be making the hard decisions. Now, this is the key. Lathan versus Journal Co. I recall studying this one in law school. This is what this case is all about. So, the trial court correctly held that the defendant's communications to prospective employers of the plaintiff made at the request of those firms were entitled to a qualified or conditional privilege. This court has previously considered the role of conditional privilege in the law of defamation. Okay? Let's try it again. The trial court correctly held employers' communications to prospective employers of the plaintiff made at the request of the prospective employers of the plaintiff are entitled to qualified or conditional privilege. Okay? That's the standard here we're talking about, which is, again, is going to turn out to be the same standard for public officials and celebrities. In Lathan versus Journal, yeah. There are also certain occasions where defamation is conditionally privileged. Conditional privileges or immunity from liability for defamation are based upon public policy, which recognize the social utility of encouraging the free flow of information in respect to certain occasions and persons, even at the risk of causing harm by the defamation. Meaning, we're going to allow employers to tell other employers that such an employee is a POS, because that's important for people to know. The communication, I mean, it's true. You would not, the modern reference check, and obviously you can tell that the modern reference check is a pale as in comparison to what used to happen. But the reference check, and it's a huge, especially in England, you remember the 100 years ago, 200 years ago, your previous employer could hold over you the threat of a bad reference. And you would literally have to move to another land and start all over again in order to beat that, which is essentially what's happening here. sorry, Mr. The plaintiff alleges that he was forced to move to Arizona to sort of escape this defamation. Do 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 do. Okay. In the case of so and so, a libelous letter from an employer to a prospective ex-employer to a prospective employer sent after the plaintiff have named the ex-employer as a personal reference was entitled to the conditional privilege. Oh God, this is why we don't call it that. The Plutz privilege Plutz privilege was privileged to give critical appraisals concerning his former employee so long as such appraisals was made for the valid purpose of enabling a prospective employer to evaluate the employee's qualifications. Okay, the privilege is said to be conditional because of the requirements that the declaration be reasonably calculated to accomplish the privileged purpose and that it be made without malice. Bam. There's your malice standard there for meaning celebrities, public officials. Bam. Public policy requires that malice need not be imputed in cases such as this, for otherwise, one who enjoys a conditional privilege might be reluctant to give a sincere yet critical response to a request for appraisal of a prospective employee's qualifications. The burden, okay, the privilege here is not absolute, it is conditional. As the court stated, the burden is on the defendant to prove a privilege as a defense to an action for defamation. When the defendant has established a prima facie case of privilege, it ordinarily devolves upon the plaintiff to rebut the showing of proof of actual malice, want of good faith or due care, etc., where such matters are material. Okay, that's burden shifting there. You say, I defamed you. I say, well, I have a conditional privilege. Look, I'm the employer. These guys came and talked to me. Okay. Then you have to say, well, no, you did it for an improper purpose. You know, there's like a statement to the secretary in which you tell him, you know, Mr. Jones, I can't wait to say what a, you know, POS this guy is. Or knowledge, like was probably the case here, that you think that he was fantastic and you were saying the guy was a jerk, just to, you know, you've got nothing but glowing reviews of him and you say that he's a jerk because you don't like that he didn't give 2 weeks notice. I don't know. Actual malice in defamation cases refers to a constitutional standard that is something other than malice as such. We'd call that common law malice is what I would probably call that. At the outset, it's important to note that there are two types of malice. Express malice, that is the malice described in the jury instruction used in this case, that is ill will, envy, spite, revenge. Okay, I take that back. Common law marriage, express malice, period. The Supreme Court also referred to this type as common law malice. Bam. Actual malice in the New York Times case is not malice at all. Rather, it is knowledge that a statement was false or published with reckless disregard of whether it was false or not. Actual malice is what is required for a constitutional determination of libel under New York Times v. Sullivan. Express and actual malice are very different concepts. It would have been better if they had used some other term other than actual malice. For example, knowing disregard. The term actual malice arises when there has been an abuse of a constitutional conditional privilege, where one makes a defamatory statement with knowledge that it was false or with a reckless disregard of whether it was false or not. That's the standard. That's a pretty high standard to prove, unless you've got some kind of evidence to state that um, the person knew it was false. Like again, as I described, here we're talking about glowing reviews that you yourself wrote out, or statements to an underling that you can't wait to get this guy, something along those lines. I'm sure where there's as many kinds of proof as infinite. The problem of actual malice arises in the cases involving First Amendment protections afforded to the media, such as newspapers, television, and radio, or comments about public officers or public officials. Take note of that, please. But the defamation alleged here falls within the non constitutional conditional privilege. In the constitutionally protected areas, the burden of proof before actual malice can be found is that there must be clear and convincing evidence. Haha. Well, that's good to know. That's quite a lot. But in those areas alleging defamation that are not protected by the First Amendment, the quantum of proof is necessary is the greater weight of the evidence. Aha. That's like 51%. Clear and convincing evidence. Let's hold on for a second. Let's just use this here. I think this is helpful. Clear and convincing is a medium level burden of proof, which must be met for certain convictions. The standard is more rigorous than a preponderance of the evidence standard. That's the greater weight one. That's what we're talking about. But less rigorous than beyond a reasonable doubt. Fair enough, which is the highest burden of proof for criminal trials. This clear and convincing evidence standard is employed in both civil and criminal charges. Clear and convincing means that the evidence is highly and substantially more likely to be true than untrue. In other words, the fact finder must be convinced that the contention is highly probable. All right. So that was the quantum of proof question here. So again, constitutionally protected malice, still malice, but the question is how sure about that there's malice do you have to be? In the constitutionally protected, it's up there, not quite at the tippy top, but it's up there. Yeah, I see. I've always heard that one is 75%, and I was kind of looking for a number that would go, with that. But don't get me started on that one. Burdens of proof. I think they're pretty flexible. Okay. It is for this reason that the defendant's reliance on Polzin is misplaced, because that case falls within the First Amendment protection, where that malice that must be proved is of a different character, and when the quantum of proof is likewise different. In Polzin, the defendant was involved in a controversy about the Mayville sewage plant. Oh, yeah, I love that one. And wrote a letter to the editor of the paper criticizing one of the reporters. The letter suggested that the reporter may have been bribed. The court held that the defendant was entitled to the constitutional conditional privilege, for the abuse of which one must show actual malice by clear and convincing evidence. We think the critics of the media, like the appellant here, are entitled to the same protection as were provided for the media in New York Times and Rosenblum cases. The defendant's letter discusses a matter of public concern. The focus on the media and the matter of public concern, which the court makes in this passage, is the key to the distinction between the constitutional and non-constitutional conditional privileges in defamation law. That's something that we will go into a lot more, and something that comes up time and time again in my practice. Matter of public concern. What is that? We're not going to discuss it here. The distinction is implicit in the United States Supreme Court creating and applying the constitutional privilege. In the New York Times case, an elected commissioner of the city of Montgomery, Alabama, sued the New York Times and 4 Alabama clergymen for libel. Mr. Sullivan was allegedly libeled by an advertisement in the New York Times which criticized the way Montgomery had handled various civil rights activities. It's a very 1973 way to put it. The Alabama state court verdict against the Times was reversed on certiorari. The court considered the defamation against the background of a firm national commitment to a free and open and robust debate on public issues and found that in the First Amendment context, a higher standard must be required, lest that free speech and open debate be chilled. The court held that a public official could not recover damages for defamatory falsehood relating to his official conduct unless it was proved with convincing clarity that such defamation was uttered with actual malice, which is the knowing or reckless falsity test discussed above. The Supreme Court later extended this test beyond public officials to public figures as well. It is clear, however, that the more exact, required to overcome the conditional privileges based on the fundamental First Amendment considerations that arise from the danger of media self-censorship and the fear of its chilling effect on free expression, and, as was said in the New York Times case, the need to purge the obsolete doctrine that the governed must not criticize the governors. Let me say that one more time. The obsolete doctrine that the governed must not criticize the governors. In Rosenblum versus Metro Media, a plurality of the court held that even if the suit against the news media was by a private person who was not a public official or public figure, nevertheless, the protection afforded by the First Amendment to the media applied, since in the issues in that case was of public interest. We honor the commitment to robust debate on public issues, which is embodied in the First Amendment, by extending constitutional protections and to all discussion and communication involving matters of public or general concern without regard to whether the persons involved are famous or anonymous. The plurality opinion noted that while ordinary preponderance of the evidence is the quantum of proof necessary in liable cases of this nature, convincing clarity is required. The court also re-examined the issue presented in Rosenblum of whether a newspaper or broadcaster that publishes defamatory falsehoods about an individual who is neither a public official nor a public figure may claim a constitutional privilege against liability for the injury inflicted by such statements. The court held that the issue was presented on a rather different set of facts than in Rosenblum. In that case, after a police officer had been convicted of murder, the attorney who represented the murder victim's family in a civil suit against the officer was discussed in a John Birch Society magazine in a false, defamatory manner. The plaintiff was identified as a Leninist, a communist fronter, and a former official in a communist organization. Oof. And Gertz's libel action against the magazine, the Court of Appeals for the Seventh Circuit affirmed the district court's entry of judgment notwithstanding the verdict, applying the Times and Rosenblum constitutional privilege standards. On cert, the Supreme Court found these standards inapplicable and reversed. The Supreme Court did not deny that the matters discussed in the publication about Gertz were a general public interest, but the court nevertheless ruled that the extension of the Times test, as proposed by Rosenblum, was unacceptable. The court noted that the private individual has less opportunity than a public official for effective rebuttal of defamatory statements and thus is more vulnerable to injury. The public figure has, to some extent, voluntarily exposed himself to attention, comment, and criticism, thereby rendering himself less deserving of recovery than the private person. Moreover, the Constitution itself does not require the application of the Times test in these circumstances, and therefore the court said, we hold, so as long as they do not impose liability without fault, the states may define for themselves the appropriate standard of liability for a publisher or broadcaster of defamatory falsehood injurious to a private individual. This was held to be true even though the injury to the private plaintiff arose out of a defamation covering issues of a general or public interest. Hmm. Don't call him a Leninist, I guess. The matter of the punitive damages in Gertz is explained elsewhere in this opinion. The trial court in this case before us instructed the jury that in order to find for the plaintiff, must find that the defendant's conditional privilege was abused and overcome, and to do that, they must find that Mr. Bagmill was motivated by express malice. The court also instructed the jury that it must so find only if it is satisfied to a reasonable certainty by the greater weight of the credible evidence. All right. While the defendants do not explicitly challenge the application of the express as opposed to the actual malice test, they do attempt to challenge the instruction as to the quantum of proof required before malice could be found. Tough toodles for them, it sounds like. Their argument is that instead of applying, this is good writing, by the way, because it leads you to the conclusion that they want you to find. I mean, you were agreeing with the court already. This argument is that instead of applying the minimal great weight standard, the trial court should have applied the middle level, clear and convincing test. As pointed out in the discussion above, this case does not fall within the First Amendment protected conditional privilege, but is a non-constitutionally protected conditional privilege. We hold, therefore, that the middle level burden is not properly applied in this case. Rather, the minimal or great weight standard is applicable here. All right. Well, thanks for sticking with me on that one. If you want to talk about, yeah, let's say punitive damages in defamation cases, maybe we'll do that. Let me know. But for right now, I think we'll leave that being and go over to some other stuff. I've got some fascinating things on reporting to Child Protective Services as a mandatory reporter. Thanks for sticking with me.